Welcome, everyone. Thank you for joining us for today's webcast, Getting Back to Business, What You Need to Know About Recalling Employees to Work in Canada, sponsored by Rudner Law. This webcast has been pre-approved for HRCI and SHRM credit. Please be sure to attend the complete webcast in order to receive your credits. If you have any questions during the webcast, click on the Q&A tab in your webinar controls and type them there. I'll post a link to the slides in the chat area once the presentation has started. A new tab will open in your browser with webcast survey. Please be sure to complete it as soon as the webcast is ended. It is now my pleasure to turn it over to our presenters, Stuart Redner and Brittany Taylor.
Great, thank you so much for having us, and thanks everyone for joining us today. We're really excited to talk to you about getting back to business, which is a major shift in the type of conversation that we've been having. Stuart and I have done a lot of webinars and posted a lot of blog posts and opinion pieces and articles in the last several months. And we can definitely tell you that at the start of this epidemic, the conversations that we were having were very much more focused on getting back to work, very much more focused on temporary layoffs, so preserving and trying to reduce labor costs as much as possible. So we were talking a lot about reducing hours, potentially doing temporary layoffs, potentially even talking about dismissals. And we've seen a real shift in the conversation in the last week or so towards this focus on getting back to business. So even though we are, I would say we're nowhere near where we were before in terms of normal. We are starting to talk about what it's going to look like when we start reopening and people do start going back to work. So we're going to talk about that today with a focus on what you need to know about recalling employees to work in Canada. Stuart, I don't know if you want to add anything before I get to the disclaimer slide.
The only thing I'll add is that this is the second webinar we've done for HR.com on COVID-19 related issues. And as you were saying, Brittany, I mean, the discussion back in early April was completely different and all about what to do and how to cut costs and can you lay people off. And now we've seen across the country, every province is proceeding differently, some more cautiously than others. But some maritime provinces have had a lot of businesses reopen, Alberta, BC, and just in the last couple of days, Ontario has laid out plans, including some things opening for the long weekend. So there's definitely a movement to get back to business, if not getting back to normal. So that's where most of our clients are focused now is how do you recall workers? What do you need to know about safety in the workplace? What are your obligations? What if people don't want to come back to work, while there still is this pandemic? So that's the focus of the discussion today, as you said. So I can shift to the disclaimer unless you want to add anything.
No, that sounds great.
Great.
So of course, because we're lawyers, we have to have our obligatory disclaimer slide. So I mean, what's really important as the takeaway from this is just that every single situation is very complex and very unique. So our intention today is to provide you with a kind of a general overview of the legal situation that we find ourselves in. It is not intended to replace legal advice. So, if you have a specific issue that you want to discuss with us, a very fact-specific question that you might have, that's probably something that is better to do offline. And we encourage you to reach out to us. As Stuart, his new favorite saying is, if you think you need an employment lawyer, you definitely do. So we encourage you to reach out to us. And then the other thing that I'll just mention briefly is that we are still seeing rapid change in terms of the development of this situation. So we do stress that this presentation is up to date as of this morning. Obviously, I think we're expecting another address from Doug Ford this afternoon with respect to Ontario. So just as of this morning, it is current and things may change and likely very well will change in the future. So keep that in mind if you are viewing this webcast some point in the future.
Yeah, and you're probably going to get to this at some point later in the presentation, but even within the last couple of hours, we've seen changes because our Prime Minister announced the extension of the emergency wage subsidy through the summer. So, we've never focused on the timing of the presentation as much as we have been recently, but it's very true that even webinars we did a week ago are not necessarily up to date, and even this is slightly out of date because the wage subsidy has been extended in the last couple of hours. So be very careful about relying upon this in the future or any other information that you got that is not right up to date.
Yeah, excellent. Well said.
Mm.
So let's talk briefly about the agenda for today. As I mentioned when I was doing our introduction, today's focus is really going to be on bringing workers back. So we're going to be talking about how do you bring them back? What are the risks if you don't bring them back? What are your options in terms of making changes if you do bring them back to work? We're also going to be talking about health and safety, work refusals, what happens if somebody refuses to return to the workplace because of safety concerns. So that's basically what we're going to be covering here. And the first thing that we're actually going to start with is a general kind of summary of everything that's changed since we did our first webinar for HR.com back on April 3rd, which seems like years ago now. So a lot has changed since then. So I'm going to be running through really quickly kind of the major changes that have taken place. And of course, we're going to end by summarizing the lessons that we've learned through this process. And finally, answering some questions from our attendees. So please do feel free to populate the question and answer box as we're going along, and we will get to your questions hopefully at the end of the presentation. Okay, so let's talk about what has changed. So I guess one of the earliest changes that now seems like old news, but was very exciting at the time that it happened, was the COVID-19 Emergency Response Act #2 was passed as of April 11th, 2020. And this is the piece of legislation which formalizes the terms of the Canada Emergency Wage Subsidy Program, which has been a real game changer in terms of our ability to discuss returning employees to work, because obviously especially in Ontario, there are still a lot of businesses who are not able to operate and who perhaps couldn't have recalled their employees in the traditional sense, but thanks to the wage subsidy program have been able to bring employees at least back onto the payroll, so they're no longer in that layoff situation. So I'm going to talk a bit more about the wage subsidy on the next slide. So I'm just going to move past that for now. And talk about the expansion of the Canada Emergency Wage Benefit, the CERB. So previously, this was available only to individuals who had specifically lost their job due to COVID-19. And the requirement was that that individual had to be completely without income for at least 14 consecutive days. So pretty quickly, the government realized that this was eliminating a pretty significant number of groups from being able to apply for the CERB. And so adjustments were made on April 15th, actually, which also seems like a really long time ago. So the program was expanded so that workers who are earning up to $1,000 a month can still qualify for the emergency response benefit, which was a huge help to a lot of employees who were still working, but whose wages had been significantly reduced by their employer in an effort to adjust to the COVID-19 world. In addition, the CERB was also extended to apply to seasonal workers who had exhausted their regular EI benefits and were unable to take their usual seasonal work. And in addition, workers who had recently exhausted their regular EI benefits and were unable to find a job because of the state of the job market as we're currently seeing it. So that's been some really exciting changes there. In terms of other changes that we've seen, obviously one of the biggest things that happened is that the applications for these programs actually were opened up for individuals to apply. So for quite some time, we were hearing a lot about these programs, but no one knew even when applications were going to open, let alone what those applications were going to look like. So since April 3rd, we've seen both the applications for the CERB, which were a lot earlier, and the emergency wage subsidy program. So those are both now available for individuals and employers to apply for. And of course, we've also had continued announcement of initiatives to assist Canadians and Canadian businesses. And I've kind of, I've put this as just one point on a slide, but that's because, like I was saying at the beginning, we are constantly getting new announcements, not just in terms of adjustments to existing programs, but about new programs and new initiatives that are coming into place. So I'll talk briefly about some of the key ones that have been introduced since we last did our webinar. So specifically for individuals, we've learned about a temporary wage top-up for low-income essential workers. So this was something that was initiated by the federal government, but is actually being dealt with on a provincial level. So every province is going to be a little bit different. But essentially what's happened is that all provinces have confirmed or are in the process of confirming their plans to basically cost share a wage top up for those essential workers who have had to continue working during this COVID-19 crisis. And that worked out to about $3 billion in federal support initiatives geared towards assisting these workers. And again, this is determined on a provincial level. So every province will have or has different requirements with respect to who will receive the support and how much support is going to be provided. So that's a really exciting initiative. We've also had a lot of other more group-specific initiatives announced. So we did have the Canada Emergency Student Benefit announced recently, which is intended to provide support to students and new graduates who are otherwise not eligible for the CERB program or for regular EI benefits. And that basically works out to up to $1,250 per month for eligible students, and actually up to $2,000 a month for eligible students with dependents or who are experiencing disabilities. So that's a really exciting program as well. And then for seniors, we've actually seen that the government has reduced the required minimum withdrawals from registered retirement income funds by 25% for 2020. And in actually just a few days ago on May 12th, they actually announced a new one-time payment of up to $500 to offset added costs for seniors due to COVID-19. So that's another really exciting initiative. So that's all for individuals. So let's talk more about businesses now in terms of what new initiatives have we seen. And there's a lot to talk about in this section. So we saw in the very early days of COVID-19 that the government pretty quickly announced loan programs, so interest-free loan options for businesses to assist them to manage their costs during this crisis. And we've seen that these programs have been significantly expanded over time. So even some interest-free loans that were clearly geared towards very small businesses have been expanded to include mid-sized businesses, and we've got new programs announced as well. So the Canada Emergency Business Account provides interest-free loans of up to $40,000 to small businesses. And we actually recently had a new announcement of the Large Employer Emergency Financing Facility, or LEAF, for eligible large for-profit businesses who are seeking financial assistance of about 60 million or more. So we're still waiting for more details with respect to that program, but I know a lot of people were really excited to see large businesses start to be considered in terms of the assistance programs that are available. And then actually just yesterday, we had a new announcement, which it will be very exciting for fish harvesters, about the Fish Harvesters Benefit, which is essentially designed to assist fish harvesters who are expecting a 25% drop in income this season as a result of COVID-19. And who otherwise don't qualify for any of the other benefits that are available. So that's a very, very new and exciting initiative that has been announced by the government, and we will see, I'm sure, more and more of these announced as time goes on. And of course, Stuart's already mentioned the extension to the wage subsidy, which I'll talk a little bit on the next slide. But before we get to that, we've already kind of talked about this a lot in terms of the shift in focus from reducing labor costs to returning employees to work. But this has been one of the major changes that we have seen since April, which is this idea of provinces starting to figure out how are we going to reopen. So even before we were actually talking about reopening being implemented, we were already starting to talk about, well, what would that look like if we did go through with this process? And what are the criteria that we need to meet to make sure that we can reopen safely? So that discussion has been occurring for several weeks now, and we are starting to see some of those changes happen. So as Stuart has already mentioned, certain provinces have already started reopening. So including Quebec, Saskatchewan, and Manitoba, we've seen quite a few businesses reopen there. In Ontario, just this last weekend, we had an announcement that hardware stores, safety supply stores, greenhouses, things like that, they were going to reopen. But of course, the big news is now that just yesterday, Doug Ford announced in Ontario that a number of businesses are going to be able to reopen services as long as they are able to do so consistent with the health guidelines that have been presented by the province. So as of next Tuesday, May 19th, we're going to see a significant number of businesses be able to reopen in Ontario, including retail stores with a street front entrance who do have the ability to limit the number of customers in the store at any given time, whether that's actually preventing people from going in and keeping a counter of how many you have in the store, or having people come in by appointment. So that's going to be quite a significant change. We're also seeing openings for media operations, services for animals and pets, including dog grooming and dog walking, outdoor activities, and even some surgeries and health services that were not being considered before. So the list is actually quite extensive, and it is, of course, available on the Government of Ontario's website. But definitely now we are starting to see a major shift towards asking those questions. Okay, now we're actually going to be able to open in the near future, or we may be. How do I start bringing people back? So before I turn it over to Stuart to talk about that, I just want to talk really briefly about the Canada Emergency Wage Subsidy, because this continues to be a support that, like I mentioned before, is allowing employers to recall employees to work, even in situations where they may not be at full capacity or even operating at all. So what is the Canada Emergency Wage Subsidy? As I'm sure everyone is familiar with by now, this is essentially a wage subsidy provided by the government, which is equal to about 75% of the first $58,700 earned by an employee, which works out to about $847 per week. Now, of course, the amount that each employee is going to be entitled to is going to differ. It does have to be determined on an individual basis. So not every employee is entitled to the maximum of $847 per week. It is quite an individual analysis. And thankfully, the CRA has provided us with a very helpful calculator to determine what your wage subsidy entitlement is. So if you are an employer and you have not yet applied for the wage subsidy and you think you qualify, there are excellent resources available on the Government of Canada's website to assist you to determine, okay, what are my entitlements here? One thing I'll note about the wage subsidy, and this is something that didn't appear in the legislation that was passed on April 11th, but is still of significant importance because it's been emphasized repeatedly by both the federal and provincial governments that employers do have to make best efforts to top up employee income to pre-crisis levels. So we don't know what best efforts means or how it's going to be evaluated because, as I said, that was not included in the legislation. But what we are encouraging everyone to do is to make this assessment in good faith and document it carefully. So what this means, to be very clear, is not that if you are unable legitimately to top up your employees' compensation beyond the subsidy that's being provided by the government, it doesn't mean that you're not qualified to receive the wage subsidy, but you should be prepared to defend your position that you were not able to provide any top up, because we are anticipating that there will be audits of the wage subsidy program in the future by the CRA. So it is really important that if you are legitimately not in a position to provide the top up, that you have considered that carefully and that you have documented that decision-making process so that you are able to defend that decision later. So as Stuart mentioned, the program was initially in place for a 12-week period, so from March 15th to June 6th. Trudeau announced an extension, and at first we weren't sure when that was going to be, but now we have actually just learned as of this morning that it's going to continue through the summer, which actually is completely in line with the legislation, because the legislation allows further qualifying periods to be announced, but only up to September of this year. So if further qualifying periods need to be announced after that, they're actually going to have to amend the legislation to allow that to occur beyond September. So in terms of who's going to qualify for the program, you do need to have experienced a reduction in revenue of at least 15% for March, 30% for April and May. And I think what's really important to note here is that if you meet this qualification in one qualifying period, then you're automatically deemed to have met it for other periods going forward. So if you satisfy the 15% criteria in March 2020, you're automatically deemed to have met that for the 30% criteria in April, even if you are not at that level. And finally, I think what's really important to understand about the wage subsidy program is that there is no active work requirement. So we've seen a lot of employers who are a little confused about whether or not they are able to have access to this program if nobody's actually working. So really important to understand that the legislation does not require any employees to actually be working. They only require the employees to be being paid. So it is entirely possible for your entire workforce to be at home getting paid, and you're still eligible to receive the wage subsidy program. And then the last sentence that we put on this slide here, the reason that I've included it is just to make it clear how complex the legislation actually is. The qualification criteria, even though it sounds really straightforward when I try to break it down on a slide like I've done here, is actually very, very complex. And there's a lot of specific defined terms in terms of assessing whether or not you're going to fall within, are you a qualifying entity? Is this eligible remuneration that we're looking at? Is this an eligible employee? So there's a lot of questions that need to be answered before you determine whether or not you're eligible for the subsidy. And like I said, quite complex. Luckily, the resources that are available online are very helpful. So I do strongly recommend that you take a look at that if you have any questions about whether you may or may not qualify for the subsidy. So with that, I am going to turn it over to Stuart, who's going to talk to you about bringing workers back.
Great, thanks, Brittany. And before I get into that, I will point out that there is so much information, as you can tell from everything you've heard already. We have been maintaining a running blog on our website since this all started. And at times we've been updating it 5, 6, 7 times a day. Lately it's been a bit less frequent, but my point is, if you're not sure about what's happening, how things work, details of the wage subsidy, the emergency relief or emergency response benefit, who's open, who's not, anything like that, we've tried to be pretty good about having all that information on our running blog. So if you go to runnerlaw.ca, go to the blog, you'll see the COVID-19 running blog that we have, and there's a lot of information there. So, and I guess the other thing I'll add is feel free to reach out if you do have questions, and we'll steer you in the right direction. Which is probably a good segue into one of the points I wanted to make as I start to talk about bringing people back from temporary layoffs. I'd say one of our biggest frustrations, and this is not COVID-19 specific, but just generally, is that most of the issues that come across our desks or our virtual desks are the result of people not taking the time to understand their legal rights, their legal obligations, and really the legal implications of their decisions. And layoffs and recalls are probably a great example. And I'm going to talk later about the risk of layoffs, but now, as we've said repeatedly, we're focusing on recalls. It's amazing how many myths and assumptions I've heard over the last couple of weeks about how recalls work, and that you have to bring people back in the order that they were laid off, or you have to do it based upon seniority, or you have to bring back everyone. You can't just pick and choose, none of which is true. So important to make one very significant distinction here. If it's a unionized working environment, you'll have a collective agreement. That collective agreement will almost undoubtedly set out the process and the criteria for layoffs and for recalls. If you're not unionized, which of course is the majority of workplaces in Canada, you don't have those restrictions. It's possible you might have something in a policy somewhere, but extremely unlikely. The vast majority of employers don't have any obligations with respect to who they bring back and when, other than being aware of the fact that you've got time limits in your legislation. And here's where employment law becomes arguably unnecessarily complex. Employment law is regulated provincially in Canada, which means that every province has its own set of employment standards legislation. And of course, they're all similar but different. And when it comes to layoffs, there are actually quite a lot of differences. Some have time limits for how long a temporary layoff can go on before it becomes a deemed dismissal. Some don't have time limits at all. Some require a certain amount of notice. either to impose a layoff or to recall the employee. Some don't specify the amount of notice. You need to be aware of that. But other than that, you don't assume that you have obligations that you may not have. And the reality, of course, is most employers have never gone through layoffs or recalls, so they don't really know how it works. So again, as I said, generally speaking, you don't have this obligation to bring people back in a certain order. You can pick and choose. And what we're telling our clients is basically take the time to assess your needs. What are your realistic needs? Because most of our clients are not necessarily in a position to go back full steam ahead, full speed ahead, 100% of their workforce bring back. So assess how many people you're going to need. Also assess, whether some people can work from home, because the guidance we're getting is that if people can continue to work from home, they should. If they can't, assess how you're going to set up your workplace and try to maintain physical distancing, which might mean that you can't accommodate all of your employees in the workplace. So assess what your needs are, and then you can try to start to assess how many people you need, and then you can choose. And the point I want to make is that if you aren't bringing everyone back, you can pick and choose. And the only limits there are going to be that you can't do things like breach your human rights obligations. You can't make your decisions based upon grounds like gender or ethnicity or age, or particularly relevant here, COVID-19, which has been essentially recognized as a disability. So let's say someone tested positive 2 months ago. You could not discriminate against them on that basis by refusing to recall them now. Obviously, if they're still in a period of self-isolation or quarantine, you're not going to bring them back. But otherwise, you can't discriminate on that basis. Similarly, you can't engage in a reprisal. So if someone raised a concern about the safety of the workplace, you couldn't refuse to bring them back essentially as a penalty. But other than that, you can bring back whoever you want, whenever you want, subject to the time limits I mentioned. But if you go beyond those time limits, it becomes a deemed termination. So just continuing on with a few more points about bringing workers back. We're going to talk about refusals, and actually I should say Brittany's going to talk about refusals later on, and the limited circumstances in which people can refuse to come back to work if they're recalled. But one question we're getting a lot of from both sides, can you bring people back part-time, reduced hours, reduced salary, etc.? And we'll give you the typical lawyer's answer here of it depends. Generally speaking, you're not entitled to just simply change someone's contract of employment. However, within limits, you may be able to. So definitely seek legal advice before you just arbitrarily and unilaterally make those changes, because you may not have the right and you may be exposing yourself to liability. And more specifically, what am I talking about? I'm talking about constructive dismissal. So the definition of a constructive dismissal is up on the screen. It's a unilateral and substantial change to a fundamental term of the employment relationship. So things like hours of work, compensation are clearly fundamental terms. Talking about layoffs for a moment, if you think about the very fundamental basis of the employment relationship, it's that the employee will work and the employer will pay them for that work. So if you go to your employee and say, for the next little while, you're not going to work and we're not going to pay you, that is a substantial change to the very fundamental nature of the agreement, which in my view would be a constructive dismissal, unless the contract gives you the right. And I don't want to belabor this point. We talked a bit about it last time, but there is this risk that if you laid someone off, you may have inadvertently or unknowingly constructively dismissed them. There is this debate going on about whether the existing laws should apply in this totally unprecedented situation. And the argument is that it is unfair to tell an employer that they may have suffered a dramatic drop in revenue, may have been shut down completely, and yet they must continue to pay their staff at full rate. And I agree, that doesn't make sense. But the way the law stands right now is that laying someone off, if you didn't have the right to do so, would be a constructive dismissal. It's entirely possible that whenever that gets in front of a judge, the judge may say, you know what, we can't continue to apply the law as it always was in these circumstances. It doesn't make sense. But realistically, that's not going to be in front of a judge before a year and a half, 2 years. And whatever happens is probably going to be appealed. So we may not have a final decision for many, many years. In the meantime, there'll be this uncertainty unless you had a clause in your contract which allowed you to temporarily lay people off. And I'll pause briefly, and I probably did this last time too, to pat our team on the back, because we almost always recommend that our clients include temporary layoff clauses in the contracts. And if you have a clause like that, you're laughing as much as anybody is laughing in the COVID-19 world, because you have the right, or you had the right, to lay people off without this risk. So the same thing would apply to bringing people back at reduced hours, reduced wages. It's got to be a substantial change. So if it's a nominal reduction, 2-5%, you're probably okay. There are lots of myths out there as well about what's substantial. Some people say less than 10% is fine. Other people say less than 15. The other day I heard less than 50. There is no absolute rule. Every case will be decided on its own particular set of circumstances. So you're going to want to be careful, because you don't want to go through this whole process, bring people back, and accidentally or unintentionally constructively dismiss them. Because if you do, if you constructively dismiss someone, then you have effectively dismissed them, which is my segue to the next slide. So a dismissal could be either a constructive dismissal. It could be where a temporary layoff extends too long and becomes a dismissal. Or we have had a lot of clients who have done the assessment we recommended and taken the opportunity to say, you know what, we have some staff that we really don't need back and would prefer not to bring back. Now is the opportunity to terminate their employment. And you can do so. But in any of these situations, you are dismissing someone on a without cause basis, which means you've either got to provide notice or pay in lieu. And there are so many more myths and misconceptions about that. The irony is I put a calculator on this slide. It was somewhat tongue-in-cheek, because there's really no easy way to calculate what your obligations are in most cases. So if you let somebody go, there's a common myth out there that you only have to give them their Employment Standards Act notice, which is usually pretty minimal. However, it's important that everyone understands that if you let somebody go without a cause, by default, the common law says everyone is entitled to reasonable notice. The common myth out there, I put a month per year, you hear that all the time. What our courts have said over and over and over again is they will look at a number of factors, and those are on the next slide. But the point is, as I've said in this slide, it can be up to 2 years. And in fact, it can be longer in exceptional circumstances, but the unofficial max is 2 years. So you need to bear that in mind before you make a decision to let somebody go, or inadvertently let somebody go, which is even worse, because now you let somebody stay on a temporary layoff too long, all of a sudden you could be on the hook for months, if not years, of severance, which is certainly the opposite of what you're trying to achieve. So, and the third point I'll make is you can have a contract, and I'm going to come back to that, which would limit your severance obligations dramatically. So that's one strategic thing you can do. Getting back to common law for a moment, as I've said, our courts have repeated over and over again, they're not only going to look at the length of service. So 1 month per year doesn't comply with the law, because our courts have said they're going to look at a bunch of factors. The key ones are length of service, age of the employee, the nature of their work. And what we mean by that is, was it a clerical position, an executive position, a sales position, a laborer position, and the likelihood of finding new work, or the availability of similar work. How you gauge that in the COVID-19 world is sort of beyond us at this point, but somebody will have to figure that one out. But the point is, there are a lot of factors, and there are a whole bunch of other factors that courts will consider in coming up with this assessment. I mentioned inducement. If you lure somebody away from another job and then let them go, that will be a factor as well. And just to give you a sense of what this can mean in terms of the impact on your severance obligations. So consider, and this is a somewhat arbitrary set of facts, consider a 58-year-old employee, been with the company for 28 years, supervisory role. If you have a contract which limits them to the employment standards legislation, that could be 8 weeks. However, if you don't, if you're in common law, that could easily be 24 months, could even be more. So you can see the dramatic impact that a contract can have and a termination clause can have. And again, we'll come back to that, but that's how you can be strategic going forward and limit your obligations, because otherwise, as we said, you might inadvertently dismiss someone by constructively dismissing them. You might let them stay on temporary layoff too long and become the dismissal, or you might decide to let them go. But in any of those circumstances, you're going to have to give them some sort of compensation, which obviously can be quite extensive. So bear that in mind before you make any decisions about dismissals, and before you let yourself fall into one of those traps. So that's all I'll say for now, and I'll turn it back to Brittany to talk about bringing people back to work safely.
Excellent. Thanks, Stuart. So obviously safety in the workplace is going to be one of the major concerns for employers who are looking at reopening and bringing staff back to work. And I think what's really important to acknowledge right off the outset is that every province and territory in Canada has their own health and safety legislation, which governs, what an employer's obligations are, as well as what a worker's obligations are in terms of ensuring the health and safety in the workplace. But even though every province and territory does have their own distinct piece of legislation, one universal thing that applies across all jurisdictions is this obligation to take reasonable steps to ensure the health and safety of your workers. And that includes an obligation to take steps to protect them from risks that are known in the workplace. So taking steps to address known hazards, which would include the risk of COVID-19 if people are going back to work in a pre-vaccine world. So one of the most important things that you need to do is to think about ways that you can mitigate the risk of infection for your workers and your customers, if you have customers and clients coming into the office as well. So as Stuart already mentioned, the advice that we are still hearing is that if remote work is possible, that is what you should be doing. So if it is at all possible for your workers to remain at home and to work from there, that is the ideal. That's what the government is continuing to recommend in terms of the best way to keep your employees safe. Other things that you should be thinking about are things like contactless pickup and delivery, scheduling meetings by video call or over the phone, as opposed to having in-person meetings to limit the amount of contact that's happening with the outside world if you do have employees in the physical workplace. Stuart already mentioned some other things that you may need to do, such as staggering shifts or reducing the number of employees that are in your workplace at any given time. So if you are used to having a work environment where everyone is working very closely together, perhaps in a very open concept environment, which everybody's kind of been renovating their space for in the last few years, that may no longer be appropriate in a COVID world where you're trying to bring employees back to work, because it doesn't provide you with the ability to really ensure that your employees are maintaining social distancing from each other. And that they're not sharing in workspaces in a way that's going to make it very difficult to ensure that there is no transmission of any germs. So certainly restricting the number of employees in your workplace, as well restricting the number of customers that are allowed in your business at any given time, which of course Ontario is directly talked about when we've been talking about retail stores reopening. So other things that you may need to do, I kind of alluded to this already, but if you've got a very open concept workspace, or if you, for example, use satellite desks where multiple people will use the same desk and kind of share the space, you may need to think about reorganizing your workspace to make sure that there is sufficient distance between employees to make sure that, that you are not having cross-contamination as much as possible. The other thing, of course, is disinfecting and cleaning. So it is imperative that you are instructing workers on proper hygiene, that you are having common areas disinfected as much as possible, and that you are providing proper personal protective equipment if that is appropriate. So that it might include following specific guidelines for your industry. So obviously in specific industries, including dental industries, we do have infection protection and control guidelines, which are very specific for your industry. So certainly those are things that you will need to be following as well as you bring employees back to work. The other thing to keep in mind is that the government has introduced industry-specific guides to helping you to prevent the risk of COVID-19. So that's definitely something that you should be taking a look at. So rather than thinking about this in a really general sense, look at what other people are recommending, including the government. If you have a regulatory body that governs your industry, or if you have an association, it may be worthwhile to review their websites to see if they've put forward any suggestions in terms of what you should be doing to ensure the health and safety of your workers. Other things that you can do, if you have a health and safety committee or you have a health and safety representative, this is the time to activate them. So allow them to assist you in making sure that this return to work process is safe, that hazards are identified, that appropriate steps can be taken to address risks in the workplace as much as possible. Now, one of the questions that we've received a lot of is whether or not testing is appropriate in the workplace. Testing, usually what we mean when we're talking about that is temperature testing to see if an employee has a fever as they're entering into the workplace. So one thing to note about Canadian employment law, which may be a bit different than the way things are in the United States and in other jurisdictions, is that we are very picky about our privacy rights. So in this case, we do see a need to balance those competing interests of health and safety and the interest of providing and preserving the privacy of an employee. Generally speaking, in a normal circumstance, medical pre-screening or testing is not something that is usual in Ontario workplaces. It's typically something you can only do in exceptional cases. Of course, as I think we've repeatedly said, this is an exceptional circumstance. We are facing a truly unprecedented time. So it may be that medical testing, including temperature screening, is something that is appropriate to do in these circumstances. However, you really do have to make sure that you are evaluating the benefit of that testing against the breach of privacy that you are asking an employee to agree to. So think about the limitations of this type of testing, including the fact that employees who are asymptomatic is not going to capture them. Employees who have taken Tylenol before they come into work, it's not going to capture them. So there are a lot of limitations with respect to what testing can actually do for you. So consider whether the benefits of testing can actually make it worth it to implement this in your workplace. And if you determine, yes, it is necessary, we think that there's sufficient benefit here that we want to implement it, keep in mind that you do still need the consent of your employees to do that. So, I don't know how you would take somebody's temperature without their consent. It would be a very interesting situation. But you really should be asking in advance for them to consent to ongoing temperature screening if that's something that you're going to be implementing in your workplace. And then the final thing I'll say about testing is just make sure you have it done by a professional. Do not hand a thermometer over to some random person in the workplace and say, here, you're in charge of this now. This is something that should be done by a nurse that you should be bringing in who can make sure that they're taking appropriate steps to avoid cross-contamination. And then the final thing I'll just note is just confidentiality is crucial here. So you really shouldn't be doing this testing kind of in a massive hall full of all of the other employees. And you definitely shouldn't be, singling out anybody who does fail the testing process. There should be a measure to discreetly ask them to leave the workplace if they do happen to have an elevated temperature. And then, of course, in terms of preserving the results, I mean, really, if your employees are testing clear, so they're in the appropriate temperature range, then you shouldn't be maintaining those results at all. They should really just be destroyed immediately. If you are maintaining results, for example, if you're maintaining results of positive tests, then that should be kept in a very confidential environment where only people who need to have access are granted access to that file. So separate and apart from their standard employee file that perhaps anybody might be able to access. Other things that is really important to do and that ways that you can ensure the health and safety of your workplace is make sure that you've got a process available for individuals to report their concerns. So this is as simple as making it clear and communicating to employees who they can talk to if they have concerns, who they can bring their issues or risk spotting to, whether that's somebody who is a member of the Health and Safety Committee, whether that's HR, whether it's just their direct manager, some way for them to do that in a confidential and safe manner where they know they're not going to be penalized for raising the issue. So next, I want to talk about work refusals, which is a big question that we are getting a lot from clients is, well, what happens if an employee is telling me that they're refusing to work because they have health and safety concerns? So, I mean, one thing to note is that employees do have the right to refuse unsafe work. That is a right that is enshrined in our health and safety legislation, so that so for the obvious reason that we don't want employees to feel like they're being forced to jeopardize their health and safety if they come across an unsafe work situation. So what happens if an employee objects to working because they feel that there is a safety hazard that has not been resolved? Well, essentially at that point, it's up to the employer to investigate that situation and determine, okay, is there something that we can do to address the safety concern? And perhaps you've already done everything you can, right? Perhaps that you have followed my advice that's set out in the last slide, and you have consulted, your industry regulator, you've consulted your association, you've looked at the government's recommendations with respect to ways to prevent COVID. You've done all of your own risk assessments, and you've really done everything you can to ensure the safety of your workers. Then it doesn't mean that you have to take extra steps. This may just be a case where you go back to the employee and say to them, I've investigated your concern, but here's everything that we are doing to ensure that that risk is mitigated. And there's, we feel that we're doing everything that we need to in the circumstances to address that safety risk. And we hope that that's satisfactory for you. If it's not, so if the employee says to you, well, that's all well and good, but I still don't feel safe, the answer is not that you fire them at that point. I'm a little alarmed by how often I've been asked if you can just fire them at that point. No, if they're still telling you that they don't feel safe, that doesn't mean that the relationship is over or that this process is over and you just agree to disagree on the safety of the workplace. You actually bring in a third party at that point, and that third party is the Ministry of Labor, at least in Ontario. And so what will happen is that an inspector will be assigned to the case to assess the safety risk on an independent basis and determine whether or not it is safe for the employee to continue working. And so they become the final arbiter of kind of determining, okay, is there something else that the employer can do here? Or is the employee really kind of making a mountain out of a molehill, and there's not much that needs to be done here? So really important to understand that process. This is not a situation where if somebody objects to working, you just immediately lash out at them. Keep in mind that you do have obligations as an employer to address those concerns in good faith. The other thing that I would say is just on a more practical note, it may be worth your while to just say to the employee, okay, if you don't feel safe, we're going to allow you to stay home on an unpaid leave of absence. And I say that because rather than getting into a fight or a discussion about whether or not the workplace is truly safe or not, you may just be able to send the employee home and not pay them. And that may be beneficial for you in the circumstance that you find yourself, right? It may be just one cost that you can kind of remove from your sphere of concern for the moment, because the employee is at home and they're not entitled to be getting paid during that period of time. So think practically about how you want to respond to health and safety concerns, rather than just following a kind of the legal process to a T, because it may be that it is just better for everyone if the employee remains at home for the time being. Yeah. Oh, sorry, Stuart, did you have something to say?
No, I was just saying, I think it's a great point. That's a practical reality. I know your next slide, you're going to talk about work refusals in different contexts, but that's what we've seen a lot of is people have said it, and I mentioned this before, you may not be able to bring back 100% of your workers. So if you have some who don't want to come back anyway, it's often a win-win just to let them stay on layoff for now. So I just want to, I guess, reinforce that point.
Yeah, no, absolutely. It's very important to keep in mind. So as Stuart said, the next thing I want to talk about is other situations where an employee might refuse to return and their refusal is legitimate. So again, I think this is the general message that we're consistently saying, is that you should never be having a knee-jerk reaction to anything that an employee is requesting in the first place. But in particular, when we're talking about a refusal to return to work, you do have to recognize that there are legitimate reasons why an employee may be telling you, I can't come back to work right now, even if you are able to reopen. So one that we've already covered is, of course, their ability to refuse unsafe work. So if you are asking employees to come back into an environment where you have not taken appropriate safety measures to make sure that they are going to be safe, it's within their rights to refuse to return to that workplace. The other thing that we need to consider is your duty as an employer to accommodate employees who have perhaps a need for accommodation based on their membership in a protected ground. So we know that there are a lot of employees right now who are currently taking care of their children while schools are closed. So this may be a situation where an employee comes to you and says, I'd like to return to work, but I actually can't right now because I have to take care of my children. There's nowhere else that I can send them at this point. And that will trigger a question for you of whether or not it is possible to accommodate that employee on the basis of their family status. So they are a member of a protected ground, and they are entitled to accommodation up to the point of undue hardship. And undue hardship is a very, very high burden for an employer to meet. So you have to keep that in mind before, again, you have that kind of knee-jerk reaction of, no, I'm not going to do that for you. Why should I have to accommodate you rather than others? Well, because that's the law. So keep that in mind. The other thing that you need to consider is whether or not the employee is actually entitled to remain off work on a leave of absence. So we saw very early in March and towards beginning of April that a lot of provinces were amending their employment standards legislation to include new leaves of absence or expand on existing leaves of absence to make it clear that employees who were impacted by COVID-19 were entitled to take a job protected unpaid leave of absence. And those provisions are still in effect. So if your employee is telling you, I can't return to work, and it fits in one of the criteria identified in the employment standards legislation. So for example, because they are sick, because they are immunocompromised, because they are caring for children, then they are entitled to remain on a leave of absence. So them refusing to return to work is legitimate and is within their rights to do so. And you cannot penalize or reprise against them as a result of their enforcement of those rights.
And I'll jump in for 1 second. I know we're not taking questions during, but you've kind of just really answered one question we just got.
Oh, great.
The question, there's actually 3 questions, and one is almost a summary of the other 2. But essentially it's, what are the situations in which someone can refuse to work? So I think, just so everyone understands, I think Brittany's really laid those out really well, that, the starting point is if there is work available and you're directed to attend to work, you have to, it's not an option, unless you fall within one of these 3 categories. And so refusing unsafe work, a leave of absence, and we're talking about a statutory leave of absence, or a duty to accommodate. And there was one of the questions talked about someone who has health reasons or is immunocompromised, or they have childcare obligations. That might apply, so they may be entitled to accommodation and or a statutory leave of absence. But unless one of these 3 categories would apply, then people have to go to work. And if they don't, as the slide says, and I think as you've already said or you were about to say, it's an abandonment of their job. So there are certain circumstances, but it's not an option as to whether people want to go back or not.
Yes, absolutely. And I think that's a really good way of saying it, is that this should not be based on the employee's preference to remain at home. And it has to also be, especially when we're talking about safety concerns, it has to be a legitimate safety concern that is related to the workplace. So if there's just a fear of going outside, generally, that's not going to really be sufficient to raise this duty to investigate their concern in the workplace. So that has to be kept in mind as well. It is, employees have their own obligations with respect to making sure that they are behaving reasonably and attending at work, which is the expectation, unless they have one of these valid reasons not to return to work. And I think that's it for me. And I'm going to turn it over to Stuart to talk about some of the lessons that we've learned.
Great, thank you. And actually, I'll follow up on that because it did come up in one of the questions as well. And it's a question that we have been getting a lot is, so as you said, quite rightly, if someone just has a general concern about going out in public, which may be understandable, but it's not a legitimate excuse for not going to work. The question we're getting is, what about if someone is scared to go on public transportation, but that's the only way they have to get to work? And it's an interesting one. I know there are some companies out there who are providing Uber or other alternatives for their workers. Obviously, again, the ideal or the first step in the hierarchy is, can they work from home? And if they can, then they should work from home. Otherwise, as I said, I've heard of some companies offering Uber rides and other things to their employees. But beyond that, I mean, my take has been that, you know, the method of getting to work is very different than the workplace, and that doesn't qualify as a refusal to work in an unsafe environment. And even though that might be your only way to get to work, it's not a legally recognized reason for not attending at work if you're directed to. So that might seem harsh. And Brittany, I don't know if you had or had any different other thoughts on this, but my take has been that just because you have a concern about the way you're going to get to work, that doesn't excuse you from going to work.
Yeah, I completely agree, Stuart. I think you've covered it entirely, and I've seen a lot of clients who have been trying to get really creative with this. Even one client was suggesting a bus, like a school bus, to pick up employees in a certain area to bring them to work. And so I think there is an expectation that everyone's going to approach this from a good faith perspective and think about, you know, creative ways that we can try to get around these problems. Because, like Stuart, like you said, the concern is legitimate. It's just not really related to the workplace. So I would say, you know, do what you can, think about creative strategies, but ultimately it's not your responsibility to get employees to work unless it is.
Right. Yeah, no, that's an important point because it seems to come up a lot. So I'll switch gears briefly, and then we'll try to leave some time. We've answered a few questions already, but to get to some more questions. So it is a good opportunity to take a step back and adopt a bit of a more strategic approach to HR. And that's one of the things that within our firm we really enjoy doing. Obviously, a lot of our work is helping clients navigate through issues, COVID-19 being perhaps one of the most epic of those issues. But what we would like to do is what we think of as an HR checkup. Let's look at your core HR documents, your contracts, your policies, your procedures, and make them as strategic and effective as they possibly can be. And the funny thing is, we often say that doing so can help you reduce your labor costs, minimize your risk. And then we usually say maximize flexibility, maximize your rights. And that's often a less of a focus. Now it's probably more of a focus. So when all this is said and done, or if you are not as busy now as you usually are and you have more time, then take the time now to be more proactive. Think about your contracts. I mentioned this before. If your contracts don't have temporary layoff clauses, put them in. So, and when we've recommended that in the past, we often got pushback from clients who said, oh, we never lay people off. And we usually say, well, do it just in case. And we never really imagined this type of situation, but our clients have been really appreciative of that. So if you don't already have layoff clauses, put them in. If you don't have strong termination clauses, put them in. They don't have to be unnecessarily harsh. It doesn't have to be employment standards minimum, but you can have a reasonable amount of termination or severance obligation, and it's clearly spelled out. So there's no trying to assess what is reasonable in these circumstances. So update your contracts, update your policies. Think about what's happened over the last 2 months and what worked, what didn't work, what you had policies for, what you had to scramble to try to address. Things like, of course, health and safety policies, remote working policies, sick day policies, and anything else that's come up. Think about what didn't work and let's fix it now, because hopefully there's not going to be another pandemic for a very long time, although who knows, we may have a second wave, but there may be something else that comes up. So let's adjust to things now, make them as strategic as they possibly can be, because as an employer, I mean, I think we all know this, most of the laws are designed to protect employees, but there is a lot you can do as an employer to put yourself in a better situation. And like I was saying, reduce your labor costs, maximize your rights, minimize risk. So let's do that now and take the chance to be strategic. So with that said, I know the next slide is a reminder of what I mentioned before. We have an ongoing or running blog about all things COVID-19 workplace related. So please feel free to check that out. We're going to get to a couple of questions, and then I will also mention now before I forget, in addition to the running blog, we have very active social media. We have a very active regular blog. We do a lot of presentations. We have an online show. Please check those out. Feel free to reach out and sign up for our newsletter, which will keep you up to date. And of course, there's no cost, no obligation. So feel free to email us and sign up for the newsletter. And last thing I'll say before we get to questions is don't hesitate to reach out if you have questions. Brittany used my line, if you think you might need an employment lawyer, you probably do. So if you're not sure of your rights, especially in these unprecedented times, feel free to reach out to us because it's almost always less expensive to prevent an issue than it is to fix it later. So if we can help you, that's great. If not, there's no harm done, but don't hesitate to do so. So with that, let's see what questions we have. I think a few have come in over the last couple of minutes. I don't know, Brittany, if you spotted any you want to answer.
Yeah, actually, one that I think is a good jumping off point from what you were just talking about, Stuart, is a question from Gabrielle, which is, can we retroactively put in termination or layoff clauses? And this is an excellent question. And I think what's important to understand is that, you know, once you've got an employment agreement in place, even if you don't have something in writing, even if you've got a verbal agreement in place, that's going to govern the terms of the relationship until you change them. And it is open to the parties to change and adjust the terms of that relationship as things go forward. But as Stuart pointed out when he was talking about constructive dismissal, that's not something that you can just do unilaterally. So it does have to be an agreement. The other thing that a lot of employers misunderstand about how contracts work is that it's not as simple as just putting a new contract in front of an employee and saying, please sign this. Because even if they do sign it, you may not have an enforceable contract due to a lack of consideration. And consideration is something of value that is flowing to the employee in exchange for their agreement to these new terms and conditions, because you are introducing new terms and conditions into the employment relationship that were not there previously. So to answer your question, it is always possible to change the terms of the employment relationship, but you need the employee to agree to those changes. And you need to make sure that you're providing the employee with something of value in exchange for their agreement to those new changes, such as a raise or a signing bonus or better benefits or more vacation. So what we often recommend that our clients do is, if they don't want to make all of those changes at once, perhaps they can't really afford to give everyone a raise at the same time, what you should be doing is making a note to yourself, and every single time there is a change event in that employee's work life with you, so perhaps they're getting a promotion or they're getting a raise, that's a good time to ask yourself the question of, is this an appropriate time to bring in a new contract or make changes to anything that's currently in place?
Yeah, that's a great point. And that's what we often tell people is, as you said, you can't just impose a new contract, but look for opportunities to do it when you're giving them something new. So I know we were told at the outset we shouldn't go much beyond 1 o'clock Eastern time. So I'm going to answer one really quickly because that's a short answer. And then for everybody else, if we didn't get to your questions, feel free to email us and we'll do our best to give you a response. But the one I wanted to answer was, because we get this question a lot, if an employee can work remotely, can they insist that they don't want to come to the office until September? So simple answer is no. Employees can't insist they're going to work from home. But again, the guidance we're getting is that the best possible alternative is that people work remotely. So if you have employees that can get their job done remotely, we'd encourage you to allow them to do so. But if they can't, and if you direct someone to return to the workplace, they can't just pick and choose where they work and insist they're going to work from home. So I think we're going to get in trouble if we go on much longer. So we better wrap up at this point. So thank you everyone for tuning in. Like we said, feel free to reach out if you have questions. Please do monitor our running blog and sign up for our newsletter. And again, just don't make the mistakes that we're seeing, which are usually driven by a lack of knowledge. If you're not sure, just feel free to reach out and make sure you understand your rights and your obligations before you make a decision. So that way you can make an informed decision. That's about it. So thanks very much. I'll turn it back over to our host.
I'd like to thank our presenters as well as all of you for joining us today. If you'd like to view this webcast again, the archived recording will be available on the HR.com website within 24 hours. Your feedback is important to us. Please take a moment to fill out the exit survey that opened in a new browser page on your computer. This concludes our webcast. Enjoy the rest of your day.
Thank you.
Thanks.